And speaker. Oh, let's see. It's not going to speaker. It's not going to you, Holly. Maybe we need to pin you. And there we go. Excellent. So Holly Surface is with us tonight. This is the creator studio at Babe Lifestyles. I am Karen Ray. I'm the founder and host here tonight. And Holly, you work in elder care. You are a lawyer. You're going to be doing some Q&A with us because there is so much to learn about what we need to have as we enter these ages of oops, I'm sorry, I'm letting some folks in here. What are the things that we need to have around creating, wills and all that kind of stuff.
Okay.
And so go ahead and just take a minute here to introduce yourself and the topic that we're going to be talking about tonight.
Okay, well, thanks for joining us, everyone. My name is Holly Surface, and I'm an attorney with Des Moines Elder Law, and of course, that is in Des Moines, Washington. And we practice primarily law that's under the umbrella of elder law, which could include estate planning and probate, guardianship, disability planning and benefits planning, and then related litigation. And so tonight we're going to talk about some basic estate planning documents and I guess related topics. And I posted a handout in the chat if you're able to access that and you would like to follow along. And this is just kind of a general guideline for our discussions. So as you have questions, we'll take them and we'll kind of see where the conversation leads. This is going to be just general information about these documents. And if you have specific questions that apply to your specific situation, hit me up later. Because we do have a little thing called attorney-client privilege. So if you're at, if I'm advising you about your specific situation, we could get into that territory. So we don't want to do that over Zoom. So one of the, I guess we can start with talking about a last will and testament, because a lot of folks, when they think about estate planning, that's one of the primary documents that they think about. And a last will and testament is a document that designates how your assets will be distributed upon your death. And also it names an executor for your estate. A lot of folks mistake a will as a document that helps them to avoid probate. But in reality, a will is a document that is designed to facilitate a probate. You can have a probate without a will, but usually a probate starts with a will. And so within that document, it names your executor, and that's the person who you have placed in charge of finalizing your affairs and who has authority to act on your behalf. So when you're drafting your last will and testament, you want to think of, well, who's going to be good at that? Their job is to gather up your assets, ascertain who your creditors are, get your bills paid, figure out your taxes, and then whatever is left, distribute that according to the guidelines that you've set forth in your will. So a will is a good thing to have, particularly if you own real property, or if you have an estate in excess of $100,000, and that would be a probate estate. There are assets that are not subject to probate. And if you guys want, we can talk about probate avoidance strategies, because probate is not a fun place to be.
Yeah. So Holly, I have some questions here, but first of all, I just want to let you know, since you posted the link before a lot of the ladies arrived, they cannot see that link. So we'll need to repost that.
Okay.
So, and as you are doing that, my question is, you just brought up a really good point, that probate. And so what does that exactly mean? Does that mean like when somebody does a will that it could be contested?
Well, yeah,
Or it's
wills.
different?
Let's see. I'm not good at multitasking.
Okay, let's
So
go ahead. Yeah, so just while you're doing that, I'll just chat with the ladies out in Zoom land, and just know that this we will also share the documents if you ladies would like it to. You can if you're watching the replay, just go ahead and say replay, and I'd like the document so you can have those questions as well. And so, yeah, so Holly, so because I know and this may be several different questions all kind of combined in one, because I really have like no knowledge in this area. I know there's a will, but there's also a trust. So is one can go to probate, and exactly what is probate? And so which is the best? And if those are two different routes to go, which is the best?
Well, it always depends on your situation. There's will-based estate planning and trust-based estate planning. So to answer your question about probate, what is it?
Yeah.
It's a legal proceeding, and it's more of an administrative type function. And probate actually comes from the word to prove. So that means you prove the contents of your will. So you're in probate, your will is entered into probate, and an order appoints your executor, and there's a document called letters testamentary that are issued. And then your executor can take that letters testamentary to the bank, to your creditors, to title company, to whomever, and say, I have these letters testamentary. I'm the person that has the authority to transact on behalf of the deceased person. And so in that way, you can finalize their affairs. You can, gather their assets. You can deal with their creditors. You can work with the IRS regarding their taxes, and then you can distribute. So with a will, the good thing about having a will is most wills will specify that the executor can administer the estate without they call it the intervention of the court. And so the word is kind of crazy. It's called non-intervention authority, and it's kind of it's like a backwards word or circular word. But basically, the only time if you have non-intervention authority, you go to court, you get one court order, and then you can go about the business of distributing the estate and doing your job. And then, you just file like a declaration of completion when you're done. But if you don't have non-intervention authority, that means the court oversees the entire probate. So every time you want to do anything like sell property, do distributions, deal with creditor claims, you're back in court getting another court order to get authorization to do that. So that's a real hassle. That's why you don't want to not have a will if you're going to probate.
So does everyone who has a will, does it go to probate? I mean, because you've got an executor, so does that court have to say, yes, that person's the executor, go and give that, whatever you called it, the letters of testament?
Yeah, not always. I mean, some people prepare wills, but then it's not necessary for their will to be entered into probate. A lot of times folks have assets that aren't subject to probate, and those are like accounts or other type of assets in which there's a named beneficiary on them. So if you have an IRA and you designate, well, when I die, I want this to go half to this child and half to my other child, that's a non-probate asset. It's not going to pass through probate at all. You don't have to worry about it.
Oh, that's great to know. That's
Yeah,
good. That's good information right there.
Yeah, that's a good way to avoid probate, is by on accounts, you can name transfer on death beneficiaries, stuff like that. So that's one way to avoid probate.
Excellent.
Another way to avoid probate is with a trust-based estate plan. And so a trust-based estate plan, a trust is a legal entity, and the trustee holds title to assets on behalf of the beneficiaries. But the owner of the assets no longer really owns them anymore. It's the trust that owns them. Yeah. So if the trust owns a house, for example, when you die, you don't have to, I'm trying to think of the best way to say this. You don't have to go through probate to have authority to sign a deed to transfer title to the property, because within the trust is held by the property, I'm sorry, is held by the trust. So really all you're doing is changing trustees with a revocable living trust. So initially, the person that owns the assets is called the grantor or the trustor. They're usually the initial trustee, and they manage the assets until they die or until they become incapacitated. But the trust document will specify, okay, well, who's going to be the successor trustee, if I'm incapacitated or if I die. And then once that happens, the successor trustee then takes over the business of the trust. So you're just switching people. You're not.
So do more people do trust-based estate plan if they have a lot of assets?
Yeah, because
that's typically how it works.
Trusts have another benefit, which is avoidance of estate taxes. And if you're, so there's taxes for estates, both state taxes and federal, and it changes every year. But currently the Washington state, for estates over, like, I think it's 2.193 million or something, then you're subject to Washington state estate tax. And there's many different kind of taxes. So we're talking about death taxes, essentially.
Right.
And then the federal, I think, is like 12.9 million. So if you have an estate that's valued at 12.9 million or higher, then you're subject to federal estate taxes as well. So trusts are good tax avoidance tools for if you're a married couple, and you can avoid some or all of those estate taxes if you have a large estate. And I'm not going to really get into the specifics of that because it's probably very boring.
Yeah, and yes. And so we are just kind of going briefly over a lot of things. And like you said, if people have, specific questions, they can certainly reach out to you. But I do want to ask some of the ladies that are here with us, if they have a specific question or topic they would like to ask you about. So if anybody wants to unmute and ask a question right now, and and otherwise I will continue asking some questions that we have fielded from people who couldn't be here tonight.
I have a question.
Go ahead, Barbara.
Okay.
If you have a trust that was written in another state, is that does that need to be completely redone in Washington, or is that a valid? I mean, and of course, details would have to be looked at, but in general.
Yeah, they're still valid in this state, the state where you're currently domiciled.
Okay.
Even if they're drafted in another state, but it's probably a good idea to have them reviewed by an attorney, just in case your situation has changed, in addition to moving from one state to another. You might have had some other changes. So those can be addressed
Yeah.
at that time.
Thank you. That's what I suspected, and I may come and talk with you. Yeah, I've some things that need to be cleaned up in my
Yeah.
situation.
Excellent. So
Thank-
Holly, so let's move on to the next question then. Thank you, Barbara. So if you're just thinking about estate planning, what are the other aspects of estate planning that you need to be thinking about? I know you have mentioned in some of our conversations, power of attorney for
Mhm.
financial and so yeah, so just kind of give us just a brief overview of some of the things that you're going to need to kind of look at, plan, and then maybe some of the documents that you're going to need to support that.
Okay, well, powers of attorney are documents that are effective during your lifetime, whereas a will is only effective after your passing. So powers of attorney designate somebody to make decisions or to transact for you if it's a financial power of attorney during your lifetime, that they can be made to be effective immediately if you feel like you need that assistance right away, or they can be made to be effective upon your incapacity or disability. And so if you want to, manage your own affairs for as long as you can, but you're just planning on that day when you might not be able to any longer, so then you can make them effective upon incapacity. And that's usually the power of attorney document itself will say what that will define what incapacity or disability means. But sometimes it's like a letter from your doctor that says, yeah, okay, this power of attorney is now in effect, and this person can transact for you. And so there's usually financial powers of attorney and medical powers of attorney. The financial, you can designate what authority you want your agent to have, whether they can receive your income, pay your bills, sell your home. Some of them are very expansive, so it's always a good idea to talk with your attorney about what all authority you want your agent to have, because a lot of times you end up with these boilerplate type of powers of attorney that just give a lot of authority to your agent. You haven't read it all because it's very dry. And so you're not sure what's all in there, but definitely read it all before you sign it, because some of them can be like, you can make gifts or you can change beneficiaries on non-probate assets and stuff. Do you really want to give somebody that much authority, or do you just want them to make sure your bills are getting paid, that kind of thing? So there's a lot of variety within that authority that you can delegate to somebody else to help you. Healthcare powers of attorney, generally those folks can access your personal medical protected information. They can make arrangements for your care. They can hire and fire healthcare providers. They can, like during COVID, we found out that a lot of hospitals will let your agent under power of attorney in, but not necessarily your family member or something. So that was one thing. Yeah, that was one thing that came up a little bit in our practice, as we would run into medical providers that they let the power of attorney in and not the family. So it's kind of strange, but one benefit to having drafted or having executed powers of attorney is avoidance of guardianship. And guardianship is not a desirable state of affairs. Guardianship is when the court appoints another person to manage your either healthcare or your finances for you, because the court determines that you are incompetent or unable to do it yourself anymore. And so, but the court before appointing a guardian, will say, well, are there lesser restrictive alternatives available to guardianship? And if you've executed powers of attorney, then yeah, there are lesser restrictive alternatives available. They have to be functioning effectively. And that's a whole nother can of worms we could talk about. But if you have these powers of attorney, then you've already designated who you want to act for you if you're incapacitated, as opposed to having the court decide who's going to do it. And the good thing about powers of attorney is they're revocable. You can change them if you want. You can change your agent if you're not happy with that person, but guardianship is not revocable. So it's considered to be a lot more restrictive. So that's a benefit to having the powers of attorney. You know, and guardianship can be imposed upon somebody quite easily. Just for example, a scenario that is fairly common is that an older person or a disabled person lands in the hospital, and they're treated at the hospital, but then when it comes time to be discharged, either to be discharged home, or maybe they need to be discharged to like a skilled nursing or something for a little while to continue recovering. But while they're in the hospital, it's determined that they don't have capacity to consent to a discharge. So what do? You know, is there an agent under powers of attorney who can consent to that discharge and that placement from the hospital or not? And if not, if the answer is no, then a lot of times the hospital will petition for a guardianship for this person, just so they can get them out of their facility and into a more appropriate facility. So guardianship can happen to folks. And
wow.
yeah.
And that's something you don't really think about, to be quite honest. So what are some other things that maybe we're not thinking about?
Well, I mean, you could have family members that next of kin that can also assist in that capacity, but it's good to have the powers of attorney to remove all doubt, because sometimes your next of kin might be your 18-year-old child who's really not prepared to make a decision like that. Yeah. So what other things are we not thinking about? Healthcare directives. And healthcare directives are designed to go hand in hand with your medical durable power of attorney. They're like instructions to the agent. And the healthcare directive is born from the Washington Natural Death Act, it's called. And what that statute says is that adult people have the authority to withdraw or withhold life-sustaining treatment in certain circumstances, such as if they have a terminal illness or something. But the default is that you are going to be resuscitated if healthcare personnel don't know that you have other wishes. So your medical preference might be, you know, if I'm suffering from, you know, a long-term medical disease and I'm pretty much at the end anyway and my heart fails, I don't want people to come in and shock my heart and try to keep me going if I'm just going to die pretty soon anyway. And so a lot of folks don't know that the default is, yeah, they're going to try to resuscitate you no matter what. But if you've executed a healthcare directive, your agent under your durable power of attorney has it, your medical doctor and your medical team has it. They know that in certain circumstances, you don't want to be resuscitated. And those are your wishes. Now, you can also take these healthcare directives and say, yeah, give me everything, I want to be kept alive because I want every chance. I mean, it's just based on what your preferences are for your care, but it helps to make that known so that your preferences can be followed. And I think we were talking the other night about a story where the lady, she was going down fast. I mean, she was in the hospital. She was not in a good way. And the two daughters were very at odds as far as, did mom want to live or did mom want to be let go? And they were fighting about it. And it was not a good situation. Unfortunately, this lady had something similar to a healthcare directive on file at the hospital, so that she made her wishes known, because her daughters, they just weren't able to come together and do it at that point.
Yeah. So that leads me to my next question is, what if you have this healthcare directive or any of the other documents, where should those be stored? Where do they go? Are they going to different places? Like this healthcare directive, does it go to your doctor or to who holds on to those things?
Well, definitely your agent should have a copy, and that's the folks that you name in the directives to speak for you.
Okay.
Your medical doctor should have a copy of your medical durable power of attorney and your healthcare directive. And a lot of, actually the physician is directed by the statute to provide a copy of that directive to the hospital if you're admitted to the hospital. But a lot of organizations now, like Multicare has like My Chart, and University of Washington has, the online medical tools. And once these kind of get in the system, then they're accessible to anybody in that medical service that has access to that. So that's good. So providing them to your doctor for sure, and then also providing them to your agent.
Excellent. And anyone in our audience, if you have a question, if you want to just raise your hand or unmute, you can do that at any time. Because I have a whole list of questions here, so that we can prompt with, and I think they're pretty generic, so they're probably maybe hitting some of their other questions as well as. So what happens if you don't have an estate plan?
Well, a couple things we've already talked about. Intestacy is a big word, which means you just die without a will or an estate plan. And what happens in that situation is your estate is distributed pursuant to the laws of intestate succession, they call them. And the law prescribes who gets your stuff, essentially. And that might not be somebody you want. But first it designates your spouse and then your kids. And if there's no spouse and then their kids, then it goes out to your parents. And if your parents aren't living, I don't have it memorized or anything because it's kind of a long convoluted statute, but the law designates who gets your stuff, essentially.
Yeah.
And if you have real property, then you're looking at a probate, and you're looking at one of those long drawn out probates where you don't have the non-intervention authority. So that's going to cost you a ton of money too. I mean, you're dead, you don't care, but your beneficiaries probably care because they're spending a lot of money on lawyer fees to, do what with a will could be accomplished a lot less expensively.
Yeah. Wow. Yeah. It's better to plan. So yes. So here's a question is, why pay a lawyer to prepare your estate plan when you can download all those forms on the internet?
That's a great question.
Yeah, I bet that one probably comes up a bit because a lot of people think, oh, I could do this on my own. But really,
Yeah.
you've already mentioned so many things that I have never even heard of. And I'm like, and some of the consequences too.
Well, what I do a lot of at my job is litigation, because they have all these things in place for folks to try to make this easy for them, but a lot of times they just go wrong. And I like to think of, well, I guess first we can talk about what can go wrong with printing stuff off the internet. I guess there's a lot of what I call Frank Sinatra types out there. And I'm a Frank Sinatra type too. I like to do things my way. And those forms, they don't necessarily fit your way that you want, you know, so people start getting creative with them and they think, well, I'll just change this or that. And it actually turns out to be quite a big mess. One common mistake that people make is that in Washington, there's pretty, they're called will formalities. And so wills have to be executed in a certain way. And people, you know, you have to have witnesses and you have to have the witness signatures notarized and yada, yada, yada. And people have a tendency to think, well, why do I have to do all that? You know, even if the instructions say it, I don't need witnesses. I'll just have somebody notarize my signature and it'll be good. Wrong, you know, then that will is not valid. So it won't be entered into probate, and you're looking at an intestate probate for your assets at that point. So, but
Interesting.
yeah, but some of the crazy things that I've seen on these homemade kind of print them off the internet things, I've seen people put two names in a will. This is the will of John and John and Joan Smith. Okay, well, whose will is it? Is it John's or Jones? You know, canceled, invalid. You know, it doesn't work. And we had one case where we had a gentleman who spoke English as a second language, and he downloaded some of those will forms off the internet. And he had a very specific plan in mind for a certain piece of property that he had. So he tried his best to spell that out for folks, but nobody could figure out what it meant that he had tried to say. And we had experts, we had professors testifying, we had expert attorneys testifying. It means this, it means this. And it really didn't mean anything because it was just not really English at all. It was just a mess. And I know the family spent hundreds of thousands of dollars fighting over this. And that's kind of an extreme example. And I guess, you know, elder law can be a lot like family law. And because it deals with families, except we don't have divorces and things like that, but we are dealing with aging parents, end of life, incapacity. And those are situations that bring up family emotional business.
Yes. Yes. And, you know, I'm glad you brought that up, because to me, this is probably the main reason to make sure everything's just really clear, who's going to be in charge, or who's getting what, because it's an emotional time. You've just lost a family member. Everybody's grieving, and especially then the money piece comes in, and it just seems like, just take care of it. Have it all set so everybody is very clear, and then there aren't any hurt feelings either.
Right.
Yeah. So
you can do your best and try to keep everything in as good of order as you can, and hopefully there's not a situation like that where, you know, the family, you know, it's just, sometimes it just happens. It's like, who did mom love more, or who did dad love more? And then it just turns into a battle. So to the greatest extent, if you anticipate that your adult children are going to fight with one another, don't make them co-agents under your power of attorney. Don't make them co-executors of your will. Find a neutral family friend or an accountant or somebody, because remember when we talked about, well, is your power is your power of attorney functioning effectively enough to be a lesser restrictive alternative to guardianship? Well, if you've named your kids as co-agents under that power of attorney and they're fighting like cats and dogs with one another over your care, no, that's not an effective lesser restrictive alternative, and court stamps the guardianship order. So
Oh, my goodness.
yeah, so that's one thing you really need to be thinking about when you're creating your estate plan is, how well does my family get along? Should my adult children be in charge of this? Or should maybe my sibling would be a better choice because they're really good at walking a middle line or something.
Mhm.
So
Wow, Holly, so many great things to think about. So is there anything else, because we just have about 10 more minutes here. So is there anything else that is really important? So we talked about wills and trusts and power of attorneys. Is there any other thing that we should really have in place?
I did want to mention, if you're thinking about a revocable living trust as your estate planning tool, trusts kind of have to be managed and babied along. Whereas a will, I don't want to say you should set it and forget it, because wills should be reviewed, every few years with your attorney as well. Maybe you've had a change of heart as far as who your executor is going to be, or maybe somebody's died, or maybe you have new grandkids or whatever. So they should be reviewed, but trusts need to be more actively managed, because what often happens is people set up a trust. They transfer their title to their property into the trust, which you have to do. I mean, if you don't transfer your real property with a deed into your trust, then it's outside of your trust and it's not going to be distributed pursuant to the trust. And you've got this intestate asset out here now.
Right.
So what happens is, at our firm, when we set up a trust for somebody, we transfer all their property into it. But then, 5 years later, 10 years later, they sell that property, they buy a new house, and they don't transfer that new house into the trust. So now you've got a big problem. So in that way, trusts need to be managed, and the assets need to be regularly managed within the trust. So you're not having these outlier assets out here when you buy new property or sell property or do whatever. So
question pursuant to that. Holly, when you do a trust, do you, as part of all of that, do you also do what I think is sometimes called a spillover will, so that if there is anything that's not in the trust, it's not intestate, there is a will.
We do a pour over will. And so what that does, it will distribute your assets pursuant to the terms of your trust, but it doesn't transfer your asset into the trust. So it's still this asset that's out there. It's now a probate asset because you've got a valid will.
Right. Okay.
You're doing a probate now instead of having.
You just said a minute ago that, the house isn't in the trust. It becomes an intestate situation, but if
it can if you don't have the pour over will. That's true.
Okay,
but the pour over will doesn't put it in the trust. You still have a
probate. No, I know that. So here's another question, and maybe, this is not hard and fast, but in general, is a trust or is a revocable trust that becomes irrevocable when you die, or a will, simpler for the trustees or the executor to administer? Is it on a case-by-case basis?
It's hard to say. A lot of entities when you die, like they'll issue stuff in the name of the estate. So here's your refund or whatever in the name of the estate. Well, you don't have an estate, you have a trust. So that's, I mean,
Okay, I'm just.
it's hard to say
try to
how
make
it's
it-
going to be.
Yeah. Okay.
They can both be, they both can be complicated.
Absolutely. I handled helped my father with my mother, and then handled, my father's. So I have some experience doing that. And thank you very much.
Mhm.
Great questions. Yes. So Holly, as we wrap up, is there anything else that you would like to say about this topic? Anything else important that we should know or think about?
I've hit some of my major points.
Mhm.
And so, folks who have more questions, you can contact me directly, and, we can talk more specifically about your particular estate plan, and what's best for you, because trusts, wills, a lot of what is going to work best for somebody is based on their situation.
Yes. And Holly, I think the biggest key that I got out of all of this tonight, because there's a lot of things I just learned, and, just because it's not something I've been thinking about it. But I think the most important thing is all the little nuances that only a lawyer is going to know.
Yeah.
To
Well,
make sure it's super clear that it's down the right path, the best thing for you.
and that's another reason why you don't want to just kind of download forms off the internet, because you probably, when you just read the forms, you don't understand what all it means, and maybe it's not even applicable to your situation, and maybe it's not even something you want in your document. So, and a lot of times people just don't read those things, and then if you download them off the internet, people don't read them and they just sign them, and it's like, well,
oh my goodness, great topic. And so ladies, if you have any other questions, you can, like we said, you can always just make sure you send Holly a message, and we'll get the information to her, or through us, or directly through Holly. So Holly, thank you for coming and joining us today, for all this great information. And ladies that are out there joining us in our Zoom room, thank you for coming and joining us too. So have a great night.
thanks everyone.
Thank you very much.
Oh, let's see. I'm not sure we stopped recording. Oh,